Morning, I am Shana O'Toole. I am the founder of Due Process Institute and its 501c3 sibling organization, Clause 40 Foundation. I want to welcome you and thank you for leaving your home offices to attend what is now the 6th annual version of this event, in which we ask the two most brilliant constitutional litigators to help us explore key criminal cases in SCOTUS's docket. My vision in creating Due Process Institute was a simple one: to create a bipartisan policy shop to preserve procedural due process rights in the criminal legal system through any means necessary: legislation, litigation, public education.
It's premised on the belief that regardless of our political beliefs or partisanship that's happening outside in the real world, there are truly fundamental principles at work in our criminal legal system that we can all agree on. And I happen to think that this program is the perfect example of that principle at work. We consider ourselves first and foremost lobbyists for the Constitution, and we employ lawyers and advocates from both sides of the aisle. But we aren't just lobbyists. We also pursue our criminal justice reform objectives through the creation of cutting-edge research and scholarship, and through the strategic filing of amicus briefs. At Due Process Institute and Clause 40 Foundation, our mandate, our passion, is to honor, preserve, and restore fairness in the criminal legal system, abolishing acquitted conduct sentencing, supporting the public defense function, bringing accountability to the prosecutorial function, now, not 10 years from now. In the few years that we've been around in operation, we have drafted, introduced, and passed multiple pieces of meaningful bipartisan criminal justice reform, including, just recently, which passed into law in July, the Federal Prison Oversight Act. So we are getting things done at a time when things just aren't getting done, generally speaking. We can't even get Congress to agree on the naming of a post office, but we can get criminal justice reform legislation passed. We have also, thank you. We have filed scores of amicus briefs, thanks in much part to the pro bono support from many of the lawyers who are in this room. Some of these even win. And we have also educated thousands of people on a variety of criminal issues that need attention. We are incredibly grateful to the law firms that generously partnered with us today to help us sponsor this event. I'm going to actually do something new this year. I'm going to ask them to stand up and be publicly recognized. So a shout out first to Barry Boss and his colleagues at Cozen O'Connor. Where are they? And they're terrible at following directions because they're true defenders, so they're not going to do this. All right, shout out to Blair Brown and the folks at Zuckerman Spader. Thank you so much. Thank you to Doug Litvak and his friends at Jenner & Block. Shout out to Bill Petard and his colleagues from Kaiser. And thank you to Hank Asbill and the great people at Schertler, Orado, Mead, and Sears. And shout out to Andy Wise and my husband, Tim O'Toole at Miller & Chevalier. All right, thank you. We could not put on this event without their help. You're all going to have an incredible meal, and it's not free. But, in fact, even with their support, it doesn't cover the cost of this event, an event that we continue to put on for free so that anyone who wants this education, anyone who wants to be here can be, including the public defenders. Shout out to the several tables in the back, thank you all, and Congressional Hill staff. So in addition to needing more resources to put on great events like this one, we really need more funding to expand our incredibly, excruciatingly small staff and to say yes to filing more amicus briefs. So I'd like to ask each one of you, if you get value from this program, or if you support the work we're doing in Congress or in the courts, please take the time to try to support our work now. Every dollar truly matters. A $5 donation is accepted. We have made it super easy for you. There are cards on the table with QR codes that will take you directly to where you can to make a tax-free donation to Clause 40. Tax-free is the gray card. Or if you want to make a non-deductible contribution to our lobbying efforts, that would be the orange card. You can also get a super cool t-shirt. You saw them as you came in. You get one of those for making a contribution of $75 or more. So if you make one of those today, grab your t-shirt on the way out the door. If you don't like QR codes, that's okay too. You can go to our website. We've made it super easy there. Or, trust me, I accept cash, and you can just find me on your way out the door. Thank you. That was a joke. Please know that money is not the only way you can support our mission. We have amicus requests pouring in from across the country. Sadly, I have to turn down many good ones because I do not have enough lawyers to do that work, and I don't have enough of you in my pro bono cadre to say yes. So if you or your law firm have lawyers that want to be put to task on these amicus efforts, we'd love to have you join us. Give your name to Tamara, who's working the registration desk, or come up and see me and give me your business card. I guarantee I can put you to work working on issues that you care about. White collar, Fourth Amendment, Fifth Amendment, Sixth Amendment, Second Amendment, doesn't matter. We've got those cases and we could use your help. We're gonna give you a few more minutes to finish up your meal, talk with the great people who are around you. Thank you so much for being here with us today. Enjoy your lunch and be prepared to have your minds blown by Jeff and Erin. Hello, everybody. We're going to get started. We're going to have Hank Asbill and Doug Litvak do our introductions this year. Take it away, boys.
Thank you very much. It's my honor and privilege to introduce Jeff Fisher, who will speak to us shortly. Obviously, he's got a very storied career going way, way back, but he went to Duke undergrad, he went to Michigan Law School, he clerked for Judge Reinhardt on the Ninth Circuit, then he clerked for Justice John Paul Stevens on the Supreme Court, and he went into private practice in Seattle and Davis Wright Tremaine, and he was an associate and partner there. Before joining the Stanford Law faculty and co-heading the Stanford Law Supreme Court Appellate Clinic. And then later on, he joined O'Melveny and Myers, and he splits his time, obviously, between Stanford and O'Melveny in private practice. Some very interesting statistics about Jeff. He has argued 46 cases before the Supreme Court, and reportedly in the since the last 10 years, or last 11 years, he has the highest success rate of any lawyer that practices before the Supreme Court in getting cert granted, and he also has the highest success rate, even including people from the Solicitor General's office, in 5-4 decisions by the Supreme Court. I'm sure that you know many of his famous cases going back to Crawford, Blakely, et cetera. And even in the past term, in 24, he has argued 2 cases in the Supreme Court. And I want to just for a second just go back a little bit more in time to 2008, when Jeff received the NACDL's, National Association of Criminal Defense Lawyers, highest award. They give out this award once a year to the lawyer that they believe best exemplifies the goals and values of Liberty's last champion, NACDL. And Jeff was in the audience at the annual meeting in 2008. And the report of that meeting and what occurred there is as follows. Law professor Jeffrey L. Fisher said it was a big surprise when he won the Heaney Award at the annual meeting in Milwaukee on August 2nd. Based on the deafening cheers and applause that erupted after the announcement, it is safe to say everyone in the room believed that the right person had been chosen. This was about 3 or 4 years after Blakely and Crawford. Jeff went on to say that he is in favor of bright line rules. I think that all too often the government, and at times the Supreme Court, has set out to water down our most precious liberties by abstracting those rights into totality of the circumstances or balancing tests in which the cost of setting a supposedly dangerous person free is set against less tangible benefits of fair procedures. Whenever I read an opinion saying that the court is going to consider 6 factors in reaching its decision, I always know who's going to win, and it's not us. My point in advocating bright line rules in some areas of criminal procedure is to remind lawyers and judges that sometimes the only way to create a fair system is to adopt a principled rule and then apply it even-handedly in all cases, not just when it's convenient. This is an era in which there seems to be a willingness to compromise the Bill of Rights. Guess what? That was 28. It's now 2014, same old, same old. Jeff realizes there is more work to be done to ensure the Constitution is protected. Quote, "There's nothing nobler in the law than standing up for the accused in a criminal trial. I have profound respect for anyone who has the fortitude to do so. And while there may be times in which it feels like being a criminal defense lawyer is leaning into a hurricane, the work NACDL members do is essential to our democracy and in the long run will continue to advance us as people." And finally, in the words of the partner at O'Melveny, who headed the appellate practice when Jeff was first hired by the firm, they issued a press release touting all of Jeff's accomplishments, but ending with, please welcome the warm and charming Jeffrey Fisher.
So it's my pleasure to be Erin Murphy's hype man up here. So Erin is a leader in appellate advocacy and a partner at the law firm Clement Murphy, recognized as one of the nation's most foremost Supreme Court and appellate advocates. Erin has argued numerous cases across trial and appellate courts, including the Supreme Court and nearly all federal courts of appeals. Erin's expertise spans a broad spectrum of constitutional and statutory issues. She has litigated significant cases, including involving the Affordable Care Act, the Bankruptcy Code, and many other critical statutes. Her remarkable skill has earned her accolades, including being ranked as a top appellate specialist by Chambers and being named one of the outstanding women lawyers by the National Law Journal. She's truly a generational talent in appellate advocacy. Beyond her impressive legal career, Erin is deeply committed to pro bono work, advocating for diverse clients such as religious organizations, asylum seekers, and most importantly, criminal defendants. She also shares her knowledge and expertise and passion for the law as an adjunct professor at Georgetown University Law Center. In addition to her professional endeavors, Erin dedicates her time to serving on boards, including the Board of Street Law and the Mother of Light Center, reflecting her commitment to community and service. And now, while I don't have all the statistics about Erin's accomplishments at hand, I can tell you that she is well accomplished and really celebrated in the appellate law community. And so with that, please join me in welcoming Erin Murphy as one of the panelists here. Thank you.
Good afternoon. It's wonderful to see a full room and to have all of you here to support the Due Process Institute. I think Erin and I have kind of really gotten to love this program, in part because we just get to see so many faces, old friends and new people we get to meet. And it's just a wonderful organization that we love to be able to support. So somewhat in past years, we thought we might start with some kind of general themes and conversation about the Supreme Court, the term that just finished last spring, early summer, and then the new one on the horizon. And then we'll walk through some more particular cases and issues that are in front of the justices or have been recently. So you want to start, Erin?
Sure, happy to kick it off. I just want to echo Jeff's thanks that we can be here doing this again for, I guess, the sixth time. We're never quite sure what year it is, but we've been doing it for quite some time now. So, so I think there's kind of like a generic public perception that we just kind of have like this 6-3 court and just how aggressive is the 6-3 court. I'm sure I said last year I didn't think that was quite right, and this year I feel like it's gotten even more complicated. I mean, this was just really for me as someone who spends a lot of time trying to just like study the court generally and understand how they all fit together and where they're going. It was a complicated year. You certainly have some decisions where it was, kind of the party line 6-3 majority that went pretty big, but you have some really big cases where you had some weird cross sections where they didn't resolve the case at all or resolve the case on some very narrow grounds, particularly in several of the, a lot of people last year was like this big social media term, and all those cases like kind of did a little bit of funky stuff all across them. And then you have, in some things we'll talk about today, in some aspects like the criminal docket, you see some different lineups, some crossover, some issues where some justices that are newer are still not exactly where I'm sure how to read them. I'm just not totally sure where a couple of the newest, sometimes they seem to be with the criminal defendant, sometimes they're not. It seems to go really case by case. Some cases you're seeing the court really kind of like embrace all this originalism stuff, and then you have major cases like Trump immunity where they're just like not talking about it at all. So I feel like one of my big takeaways from this past term was like I had a harder time figuring out takeaways from it because it seems like they're still a little bit getting their footing of this 9 and how this 9 fits together. And I think back to a common thing that my former boss, the Chief Justice, and plenty of justices would say, and partly we had a change on the court coming at the end of our term, which is, anytime you change any member of the court, that changes the whole court. And there's been so much change over the past few years in the midst of huge decisions and a huge public spotlight on the court. And I just think they're still kind of figuring out, like, what is our approach? What do we want to take? When do we want to go big? When do we not? If we got into a discussion today about how they're even just working through, like, do we take these cases on the emergency docket? Do we take them onto the docket? Maybe not. That didn't really work out so well this year when they tried to do it a few times. And I think there's just also, partly just because of the nature of the times, just an ever brighter spotlight on the court and everything they do, and I think they're getting used to that. So I found it a term of enough contradictions that it makes it hard for me to feel like I can draw a lot of great conclusions about exactly where the court as a whole is in terms of kind of who's leading it in what direction, what we can expect, and then we kind of had them grant like very little for the upcoming term, so they're not even giving us that many data points at this point. So I'm going to be really interested to keep watching this term, especially we can talk a little bit about some of the newer justices, but watch as they're getting their footing, and the more they do, that impacts the other justices and the other justices' ways of thinking about, okay, maybe I have a better idea of how to appeal to Justice Jackson or Justice Barrett, and as advocates have a better idea, as I think a lot of that is still a little unwritten at this point.
It's so interesting to hear that because Erin and I don't exactly rehearse what we're going to say in this program, but as I was thinking about making these introductory remarks, I kind of came to the same place, which is I had a hard time coming up with like a really grand theme that encapsulates everything going on at the court right now. A few years ago, we were all saying, oh, stare decisis is under attack, or these kind of big dominant themes. And I do think it's harder right now, and I think that's an observation that I certainly share. So maybe what I'll say is I think there are two things that I'm kind of watching at the court right now that seem to be things they're trying to work through in a sense, and maybe there'll be stronger storylines coming out of it. So one is, I do think there is this issue hanging over the court with this sort of public perception of the court, and maybe even not so much from lawyers who practice in front of it or even the bar, but from the public. And the court has just been, in the front headlines a lot. Dobbs is one example, but there are plenty of others like the Trump cases this term and others. And so there is this public conversation going on about, is the court becoming partisan? Is it becoming too ideological and the like? Erin and I will talk today, I think, and especially in criminal law, where I think you can push back against that narrative. But that narrative nevertheless exists. And so I think it's one thing that's interesting to watch is how the justices react against that backdrop, if at all. And one thing that I feel like I'm noticing is more and more talk the last year or two about methodology.
Yes.
And we're going to talk today about specific decisions to give examples, but just to highlight a couple, like one is this ever-increasing emphasis on history and tradition. Erin will talk about that in the Second Amendment Rahimi case, but also in other cases. And even outside constitutional law, the court is starting to look at history and tradition. But that's just the beginning, not the end of that conversation. It's like, what does it mean to look at history and tradition? And Justice Barrett is debating that with Justice Kavanaugh, who's debating that with Justice Thomas and Justice Gorsuch. And so one thing to say is, like, what comes of this? Like, is this maybe an effort on the court's part to kind of double down? And they're doing the same thing in sort of pieces of textualism we might discuss today. Are they trying to really double down to be ever more a court and really show the public and even themselves they're a court? Is that partly what's going on? And if they are, if that's the project, like, how successful will it be? Will they settle on things that reassure the bar, the public, that they're applying neutral principles and ones that are worth following in the first place? So that's kind of a really interesting conversation I see playing out, and I think maybe we'll touch on it various times today. The other one is a little more specific to criminal law, which is really what brings us here today. And it's this move the court has made in recent years that I might think of as, to some degree, away from criminal procedure and towards substantive criminal law. And I think about a backdrop of this, hugely influential scholar, Bill Stuntz, who died way too young, and some of you may have even had the privilege to learn from him in law school. He wrote a series of really interesting articles about how the Warren Court, in effect, overdid it on the procedure side and made the process of prosecuting and trying criminal cases too difficult and too expensive in ways that triggered legislatures to up sentences, which then shifted the world into plea bargaining and away from trials. And anyway, this questioning of whether, even if you are sort of a civil libertarian, it is the best move to amp up procedure in every corner. And I think I don't know whether they've been listening to Bill Stuntz or not, but I mean, one thing that you see now is the court is a lot less interested in procedure. We were talking earlier about how the court hasn't taken a Fourth Amendment case in a while, like a bread and butter Fourth Amendment case. And you could think of any number of other, not to mention Miranda and goodness knows habeas. The court is not really interested in these kind of tools anymore. But, and again, we'll talk about this today, what is an ever-increasing part of the court's docket is just regular substantive criminal law. Does the statute reach this far? Should these people be prosecuted at all for this conduct? And that seems to be capturing the court's attention more. And I don't know whether you have your own thoughts about why that might be, but I think it's just a descriptive observation.
Yeah, and I think it does, if we were a little different audience, one thing I would talk a lot about is it was a big term for administrative law last year, obviously. And, but I think there's a connection there. I think the court is extremely, I think both, we'll talk today about some of the court has had this steady diet of over-criminalization cases, where they tend to come out in the criminal defendant's favor by rejecting what they view as an overly broad reading of a criminal statute, and I think that's animated by that same impulse that there's a pretty wide cross section of the court that has this real skepticism, not just of agency action, but kind of like government action that interferes with individual liberty, like at all, whether it's coming from through criminal process or through administrative agencies, what have you. And I think it's some of those same instincts that, there really is like, I think it's probably the most like libertarian conservative group of justices you've had on the court for quite some time, that to have that really be not just like, coming from the right, but from a libertarian perspective there. And that I think is a big reason why you have some of the divisions you do among even the six, because they are at varying points of the spectrum in sort of that like kind of old school conservatism versus a little bit more libertarian. And I think they find really attractive these cases that they think are kind of, to their mind, like perfect illustrations of the concerns about particularly the federal government just having gotten too big and too much in everyone's business. And you see those way more than you see any kind of like substantive constitutional criminal cases these days. They seem much more interested in these cases that have like sort of a due process bent to them, but they're really ultimately at their heart are kind of statutory interpretation cases.
Yeah. I'll just say a couple more things. I'm often asked when I do programs like this about the new justices on the court that we're in a sense still getting to know. And so the most recent two appointments, Justice Barrett and Justice Jackson, I think have both really interesting terms. Yeah. One conversation about Justice Barrett is maybe she's, to the surprise of many, becoming something more like a median swing justice in many ways, and in some ways because maybe she's a little more incrementalist than some of her more conservative or other conservative colleagues, in the way Justice O'Connor used to be, perhaps, and also because I think one thing that I've noticed about Justice Barrett, and this is especially appearing in front of her, is, and it's maybe even surprising because most of her career was in academia before she took the bench, but I would say she might ask the most lawyerly questions of anybody on the court right now. I mean, she gets really, really deep in the record, really deep into the guts of the statute, Romanet 2, subsection B, how does it fit together with this other thing? I mean, she's really, really in the weeds of the cases, and asking really, really good hard questions of both sides. And I think that's been really interesting to watch in ways that, I said Justice O'Connor, it also reminds me a little bit of my old boss, Justice Stevens, where he would sort of look for maybe a narrow or even quirky way to kind of resolve a case, short of doing something kind of big and dramatic. So I think she's going to be a really interesting justice to keep watching. And Justice Jackson, maybe all the more so, coming out of the gates with seems like a real project to develop her own voice, like immediately. I think I'm right that she wrote the most separate opinions of any justice on the court this past term, which is pretty unusual for a junior justice. You have to go out of your way, in a sense, to write more opinions than anybody else on the court. And I think by like 3 times.
It's not like this is a court where like nobody likes to write a lot separately.
Yeah. And she's writing opinions that aren't necessarily predictable either. When I was looking over the cases we're going to talk about today, there are 3 criminal cases last term where she wrote separately and disagreed with the other 2 Democratic appointees on the case. Twice where she voted for the prosecution and they didn't, and another time where she voted for the defense and they didn't. So she's really, I think seems to be really either, certainly has an independent perspective and is very energetic about kind of finding ways to express that and make her mark and her stamp, very early on the court.
Yeah, I'd say, about Justice Jackson, the other thing I found really interesting is, I think we'd kind of reached this point. I mean, probably 5 years ago or something when Justice Kagan said, we're all textualists now, however that, whenever that was. And a lot of people always talk about, Heller is kind of like the triumph of like, everybody's a little bit originalist now and everybody does that. And she has really shown up and like, nope, like I am not willing to just be on board with either of those projects. Please tell me about the legislative history and, does this whole original thing really make sense? And so I think I think there was a common perception that we've kind of moved to a point where most of the court is talking in that language, and she has shown up and said, I really want to push back on whether that is the right way. So to your point about methodological debate, there's definitely a lot of methodological debate going on among those who have been renewing publicly their commitment to originalism. There's also that debate going on about kind of is that the right approach. I have found Justice Barrett just really interesting this term. I mean, she it's like she's doing kind of figuring out her jurisprudence out loud, so it's really interesting and fun to watch as a lawyer. I mean, a lot of that is happening at the court. It's actually, if you kind of get past the obsession with all the big cases, like they're really interesting right now. Some of these writings that are happening with all this back and forth, if you're just like kind of lawyerly and you know, they're giving you so much insight into just the way they're thinking through all these problems, and you see that from her with just the nature of the questions she asks and some of the things she writes about. I do think my own sense at this point is I think there's a little bit of a misperception. I mean, you know, she's definitely become one of the justices who is just like, as a factual matter, you know, kind of more likely to be in the middle three in the sense of less predictable about where she come out. I think people tend to, like, whenever that happens, just think like, oh, that's because that justice is sort of like more moderate, or, you know, and I don't think that is not my sense. I think she is more, it's an incrementalism, but a little bit different from how I think about the chief's incrementalism, because his, to me, is thinking about the court being incremental and like helping the public kind of see where we're going. We're going to say it twice before we hold it the third time. You know, this pattern you've seen of like, that is sort of about, I think, a little bit of an outward-facing thing. I think my perception is when she's being asked to do something, she wants to know the consequences of what that is, not just for this case, but for like 18 cases down the line. And if you can't kind of help her see exactly where she's going in the long run with something, she's not going to go there yet. And so I think she really is like just being very thoughtful about that from the perspective of like, I don't want to be here and say something in my first year or two that then 5 years down the road, I'm a little like, was that quite right? And, you know, and I think she's also probably, in my sense, I think like maybe one of the most persuadable justices up there, in that I don't think she necessarily comes into things with her mind totally made up. I mean, she may, even if she's coming in with an instinct, and there's definitely been some of these public reports of her being someone who flipped in some cases and stuff, and some less public reports I've heard of her being someone who did. And so I think she like is really genuinely like asking questions at cases, not, you know, sometimes some of them are asking them more so people hear them, or they're, you know, and I think she's really just genuinely like, I'm working this out. So it's been fascinating to me to watch her and try and get like a read on exactly where she's coming from.
Yeah, and those are great questions to get at oral argument. That's why you show up and prepare, right?
Yep.
Well, I'll say one quick thing as a transition into our cases, which is the other justice that might be particularly noteworthy out of last term is the chief, Erin's old boss, and with some of the writing coming out of last term was the chief kind of took control of the court again, and you know how true that is or not, he certainly wrote a lot of the big opinions.
He certainly did.
To the court this term. So we thought we'd start with the Trump cases because they are criminal prosecutions after all.
Yep.
And we'll start with maybe some reflections on those cases, the two that are criminal prosecutions, and then kind of move on from there.
Yeah. So it's interesting. You know, a lot of times, I mean, I don't do like criminal law quite as day in, day out as Jeff, so sometimes I got to get back into things. And like the couple big cases this year that are criminal cases are not exactly as criminal cases as you might think. You know, I think I'm like, Trump immunity. I guess that is a criminal case.
It's a criminal prosecution.
But it's very different from, you know, the issues you're normally dealing with. But I'm sure, you know, I don't need to tell anybody what the result was unless you were living under a rock all summer. I think we all know that the court ruled 6-3 in favor of some degree of immunity for official acts for former presidents. So I'm going to instead really go more to just like a little bit more of some observations about the case. I have to say, you know, for me, I was not terribly surprised by most of the opinion when it came out, in part as someone who had kind of read the briefs, had the opportunity to listen to the arguments, and watch the evolution of the case from the DC Circuit's position to the way it was briefed to the way the advocates argued it at the court. And by the time, and you know, we started in the briefs, and you had two pretty seemingly extreme positions, because it essentially seemed like, you know, on the one hand, the government's saying like no immunity kind of for anything, and on the other hand, it sounds a little like Trump saying like blanket immunity for everything. And I think my sense, based on where both advocates were at argument, is they both got some feedback along the process of like, maybe try to say, like, moderate that a little bit. And by the time you got there to the argument, I think there was pretty much like wide consensus about kind of like, you know, the unofficial acts, like, we're not claiming immunity, but unofficial acts are fine. And then while they had different ways of getting there, kind of both sides were getting to the same position of if you're really dealing with like that absolutely core presidential stuff that courts don't usually have the ability to review. You know, I think Michael Dreeben had a little bit different way of coming at it than immunity, but he was sort of giving that same stuff up too. And so by the time, you know, you were really at argument, I think it was mainly a fight about the middle. And it's so classic Chief Justice Roberts, the way he ended up writing it, which is essentially the opinion just like takes Justice Jackson's old framework from his Youngstown concurrence and just kind of takes that and takes, you know, this idea of the spectrum, and at the one end this is clearly in, and on the other end that's clearly out, and then everything in the middle is sort of this difficult twilight zone. And I always, you know, everybody always talked about what like that wonderful that concurrence is, and I remember being back in law school and I was like, okay, you know, this is like, I get it, this is really a helpful framework, but like, it's really nothing more than a framework, and it doesn't really answer a heck of a lot of questions about what the actual scope of executive power is. It just gives you tools for trying to determine the answer to that question. And I think, like, to me, that's one of, you know, the fairer critique to me of the court's opinion than that the notion that it actually gave the president, you know, kind of blanket immunity, since it really didn't, and really said, you know, when it comes to a variety of official acts, it's going to depend. To me, you know, some of the frustration is like, okay, well, that doesn't even tell you a heck of a lot. I mean, at the end of the day, they didn't even actually decide whether many of the allegations in the particular indictment before them were or were not things that were covered by presidential immunity, and instead kind of gave some examples about how you'd think about this framework, and then said everybody else go and figure it out. And, you know, so I think a lot of the discussion of the opinion as having kind of reached this extreme conclusion is just not right and just not fair and not what it said, since it kind of went out of its way to not answer a lot of questions about when you're talking about the official acts that are outside that really core scope that, like, Congress can't even kind of regulate what the executive is doing, and left a lot there to still be determined. And yes, it created a presumption of immunity, but, you know, left the possibility that that doesn't mean it can't be overcome in particular cases, and left open things like some of the communications here with, like, the vice president, and some real questions like that. So it did, though, of course, have the ultimate effect of making clear that this indictment wouldn't survive, and that's in part because the thing that did surprise me a little bit is the court went beyond all of that and resolved this separate question about whether you can use the immune conduct, the official acts that are immune, as evidence in support of your charges about things about non-immune conduct. That issue, I will tell you, as, you know, having read the briefs, like, there was not a lot of time and attention spent on that issue in the case. There was not a lot of time and attention spent on it, a little bit more at argument, but it was not like that was kind of the central dispute, and I didn't think going in that the court was going to resolve that question. And they did, and they resolved it by saying, you know, that you can't have the immune conduct even be part of your efforts to prove up your case against the non-immune conduct. And that had real ramifications for this particular case, because this indictment had been crafted in a way where the court did say certain things, particularly communications with DOJ officials, were out. And so kind of you couldn't really survive the case as it is, which may have been part of why the court reached out and answered that question here. So we do have, as many of you probably know, a new indictment in the case. The saga continues, and it removed basically anything the court specifically said was immune conduct, but left in a lot of the stuff that is still kind of, that was flagged and not resolved, in particular some communications with the vice president and some issues like that, you know, if that ever all continue to get litigated, would be really interesting. I have my doubts about whether it, like, really will. We'll see what happens. But to me, you know, that was the bigger surprise than kind of where the court landed on the principal issues in the case.
Well, I'll say a couple quick words about the immunity case, and then I'll talk about the Fisher case, which also plays into this new indictment that Erin just mentioned. So I guess I partly agree with you and partly see a little different. After the oral argument, I was certainly not surprised too much where the court landed, but I was a little surprised at the force at oral argument of the conservative wing's desire to fully or presumptively immunize presidential conduct that would be subject to an indictment like this. But the thing that struck me about this case, and I flagged this methodological question, and we'll talk about it today in various ways, this one seemed to me maybe a little more consequential, I have to say. And I think, again, justices on different sides of the aisle have been consequentialist over the years. Justice Breyer, I think, was quite consequentialist, and I think some more conservative justices can be consequentialist. And the thing that struck me maybe most notably from the oral argument, and I have to say, sometimes I put more stock in oral arguments than in opinions. Sometimes the oral arguments themselves, I'm not saying it's necessarily true in this particular case, but just as a general rule, if you all are interested in the court, or certainly if you're trying to apply one of its decisions, it's often more enlightening to go back to the oral argument because you get them all talking, not just who's writing the opinion, and you get even more honesty sometimes, I think. And so the thing that was interesting in oral argument was this sort of consequentialist concern that if we allow this prosecution to go forward, this is just going to create a cycle. And so I think that when people say the Supreme Court was trying to sort of protect Trump, I'm not sure that's exactly right, particularly for the votes that really mattered in the case, that were the ones most in play. I think they're maybe trying to protect themselves, and they didn't want to be, dragged into not just this prosecution, but what Justice Kavanaugh said at oral argument. He would imagine to be just a cycle of tit for tat, maybe starting as quickly, especially given who the two candidates were at that time, then former President Trump became the new president. He was already saying we'd indict, former President Biden and the rest. And so I think that concern from the court seemed quite animating from my vantage point. And I guess you can just decide what you think of that. Like, is consequentialist reasoning valid as compared to other forms of constitutional interpretation? And I just think that's kind of a sad statement. Like, if that is true, that's kind of what was going to happen. I'm not saying it's wrong. Maybe it's actually right, but it saddens me a little bit. I just have to say that. But also just returning to the fact this is a criminal prosecution, at oral argument, Justice Alito also was saying, and remember, prosecutors can get an indictment off of almost anyone. So, the former prosecutor himself saying, I don't trust prosecutorial discretion, at least in this context, was kind of a striking moment of the oral argument as well, and I think plays into this overcriminalization concern that the court is having, where I framed this as substantive criminal law. Another way to frame this is prosecutorial discretion is not thought of the same way across the bench, I don't think, in general, as it used to be. And that actually brings us to the other case that implicates President Trump. This was not a Trump case, and even though it's called Fisher, it is not my case either. There's a C in the last name, so that'll hopefully prove it to you. So this case arises from the January 6th events, not too far from where we're sitting here, in a series of prosecutions under the Sarbanes-Oxley Act, including for Mr. Fisher. So the Sarbanes-Oxley Act, as probably most of you remember, was enacted in the wake of the Enron scandal and the document destruction that took place in its unraveling. And the act prohibits corruptly altering, mutilating, or destroying documents or other tangible records. And then the following subsection also prohibits, quote, otherwise obstructing, influencing, or impeding any official proceeding. So the question in the Fisher case is, were the January 6thers, and Mr. Fisher in particular, who showed up at the Capitol and entered the Capitol in the midst of the vote, the election certification procedure, in violation of this otherwise obstructing or impeding any official proceeding clause of the Sarbanes-Oxley Act. And so, as a textual matter, you kind of had cross-cutting indicators here. The word otherwise coming after the prior subsection dealing just with document destruction suggests maybe this is just kind of a cleanup for any other form of document destruction. On the other hand, the phrase any official proceeding is quite large and sweeping and doesn't talk about documents at all. And so you have these dueling textual arguments that you might make in the case. 3 justices said, we're going to focus on the latter, any official proceeding. Justice Barrett, who ultimately wrote the dissent in this case, said this is an open and shut case. In her view, this is a very simple case of just straightforward textual interpretation. But a 6-justice majority, in an opinion by the chief, disagreed. And they said, no, the more interesting word is otherwise, and hooking up with the prior subsection tells us as a contextual matter that we shouldn't overread this section, we should read it narrowly. And again, overcriminalization being one of the concerns here. I think whatever the justices, or you might think of the January 6th folks, Justice Gorsuch, for example, asked an oral argument, what about civil rights protesters that stay just sit in on the courthouse steps and impede the lawyer's ability to come in and out of the courtroom? What about somebody who's a heckler in a courtroom? Any of these things might be said to obstruct or impede an official proceeding, but they're kind of thought of as forms of protest. Now, maybe the First Amendment at some point is the answer to that concern, but they have genuine overcriminalization concerns, I think, that drove them in the majority to read the statute narrowly in keeping with what they've been doing for the most part in recent years. As Erin said earlier, there's an interesting concurrence by Justice Jackson where she talks about the, quote, enactment history. So it's not legislative history, but I'm pretty sure enactment history is the same thing as legislative history. And she has several pages of like the old-fashioned congressional record statements and the quotations and saying, this is how I'm resolving this case based on congressional purpose and intent. And this isn't a textual case
it's like the anti-Scalia opinion that now you're coming out like, I want you to be clear, I am relying on the legislative history.
Exactly. So an interesting opinion from her as well. And the result of this being that 2 of the 4 counts in the Trump indictment that were also based on the Sarbanes-Oxley Act seem to be in all likelihood out of that, seem to be out of that case now.
Yeah. No, I totally agree. I think for the court, like that was, I don't think in their mind that was a January 6th case. It was just fits right into this trend that we've seen for a long time on the Roberts Court, going back through a variety of membership of, and a lot of the issues here, like even go back to like Yates and some of those earlier cases that have been this same debate that's been going on on the court of just real skepticism to broad understandings of some of these statutes. And another case that we saw this term with some of the same dynamics was the Snyder case, which involves the question about Section 666, which is the statute that criminalizes bribing state and local officials. And there'd been this question kicking around for years about, does that encompass gratuities? Giving a gratuity to someone after the fact, an official who did something for you. And 6 of the justices said no and interpreted the statute to not cover that. And you get those same dynamics going on in both of these of like that concern of like, look, if somebody really makes some agreement at the front end that they're gonna pay you to, later on, like of course that's gonna be covered and we don't need to cheat to get there because that is a bribe, it's just a delayed bribe. But what we're worried about is like the everyday person who just kind of sends some gift to whoever, whatever the official did something nice for them. And how are we supposed to distinguish those things and call one of those like, if all that's a gratuity and it's all just sort of on like a frame of mind thing, we're just really worried that we start to capture all sorts of things that we don't ordinarily think of as criminal conduct. And I think that's just the way this court comes at a lot of these statutes that kind of inject criminal liability into areas that you don't necessarily think of as traditional kind of criminal activity. The court is really thinking about it from that perspective of like that everyday citizen, how might this kind of inadvertently capture them? And we're just not sure, they've been saying for quite some time. I think particularly going back, I think it was in the Yates case that particularly they were like, we're done with hearing the answer of don't worry, trust the government, trust prosecutors. We won't go after these cases because they've seen too many of the really aggressive cases pop up. And I think that now we're seeing that creep past even the like crazy cases to it's just become a little bit of an MO for the court that they look for those issues in lots of contexts and worry a lot about those interpretations of statutes. But you do across these cases start to see a little bit, there are some dissenters now who are like, hey, we're supposed to all be textualists now, and it sure seems like you're saying, well, Congress can't really have meant what it said, because that would be crazy. And it is a little bit what they're saying in some of these cases. I think it's not a totally unfair critique. And I think it gets into some of that really interesting debate we've seen, particularly with Justice Barrett bringing up these ideas of how we think about some of these canons of interpretation, things like she's talked about it particularly in the context of the major question doctrine, but how do we think about like the rule of lenity? How do we think about the traditional kind of federalism canon? Are those interpretive canons, or are they sort of things where we say, like we're almost going to require clear statements if that's as far as you want to go? And I think a lot of that methodological debate about how to do statutory interpretation is happening in some of these cases where you have some justices who have a little bit more of a reaction of, we're just not going to read the statute to reach things we don't think it should read, even if that might be sort of the natural way to read it.
Well, Justice Gorsuch wrote, I think, a separate opinion this term where he said, the easiest way to understand what we're doing is just think about the rule of lenity. Unless the criminal statute unambiguously reaches this conduct, we're not going to read it that broadly. But virtually everybody else on the court says, no, we're not doing lenity. And so that actually makes it a harder thing to understand. But the bottom line seems to be, as Erin says, I think, these expansive constructions of criminal statutes that reach what the court might think of as everyday conduct, or at least something that states could handle as well or better. Right. They don't seem to want to get involved in. And I would just say from the practitioner standpoint, in a way this makes the work really fun. Instead of, when I'm writing these briefs nowadays, and I'm doing one right now, I'm doing a case right now, where it's like, of course you're going to do your Westlaw searches and you're going to get the dictionary out for the words in the statute, but the best thing to do is go take a walk and think about all the implications of the government's position. And to use the Snyder case, if you drop a box of donuts off at the local police station and say, thanks for what you did last week, have you just committed a federal offense subject to 5 years in prison? That seems weird. And those arguments in the brief in the Supreme Court, I think, are moving the ball much more in many of these cases than all the other stuff.
Yep, absolutely. Absolutely.
Where are we?
I think we're turning to the Second Amendment.
There we go. All right.
So,
another one of what you say is not really a criminal case.
Yes, and I will begin by saying, so I do a lot of Second Amendment work. I have done virtually no Second Amendment work in the criminal context, and that's for a reason that I think Rahimi showed this year. They're not the ideal cases to take to the court. This was, since kind of Heller and the court getting in, this is really the first of the major cases the court had taken in the context of a criminal defense rather than what we typically are bringing, which are affirmative lawsuits brought by law-abiding citizens challenging the constitutionality of constraints on their rights. It's not like you should have different ways of coming about questions just because of the context in which they arise, but in the same way that some of those dynamics matter with interpretation, they probably matter a little bit when the court is thinking about the constitutionality of firearms restrictions and particularly criminal laws. So Rahimi in particular involved a challenge to the provision of federal law that prohibits individuals who are subject to a domestic violence restraining order from possessing a firearm. So it's individuals who are not necessarily any kind of conviction, but subject to an order, and the prohibition on possessing a firearm would last as long as you're subject to the order. And a lower court had held that unconstitutional, applying the Bruin test, and that's how it ended up coming up to the Supreme Court. This is only the second time since Bruin that we've had a chance to hear what the court is thinking, at least in the Second Amendment context, about how all of this historical tradition works. And as you may recall, the basic concept the court laid out in Bruin is the way we're going to do Second Amendment challenges is first, we'll have this kind of threshold textual inquiry to ask, are you like engaging in, does this statute implicate the Second Amendment at all? Does it have something to do with keeping and bearing arms? And if it does, then the burden shifts to the government to justify the statute via historical tradition, identifying past analogous laws that reflect the same basic tradition and justify what the state is, or the federal or state government is trying to do today. So really, we've for quite some time obviously had the court talking about looking to history and tradition and all of those things in many contexts, but not putting into action in quite the way it's doing in the Second Amendment context, saying, we are explicitly disavowing the notion that we're going to apply tiers of scrutiny or any of those modes that we use in any other constitutional context. Here, the sole mode of constitutional analysis is to judge a present-day law via its historical predecessors and decide based on that whether a law is constitutional. Litigating these issues in a lot of different contexts, this has been, candidly like a mess in the lower courts. It's all over the place. You go into some courts, some courts are like, yeah, I feel like I get this. Some courts are extremely hostile to it, and I'm not a historian, I don't know how to do any of this. Some courts view it all as, right, just give me briefs about history and I'll resolve that as a legal question. Some courts say, no, we think this is a factual question and you need to put on experts and I'm going to decide who's credible. And, so it's really been like interesting, but also very messy. We have a trial going on right now in the Southern District of Illinois, where it's just people coming in and testifying about how firearms work. So it's really it's a very interesting area to be practicing in. But one of the biggest questions I would say, just methodologically after Bruin, has been the question of, okay, we've got this idea of comparators, but like how high of a level of generality are we talking at? How do we decide what historical analogs are good enough? And there was definitely some language in Bruin that was like pretty aggressive. In particular, the idea that they basically said, look, if it's basically a law that could have been passed in the past, if it's a law where the same problem existed and the legislatures didn't enact that law, that itself tells us you can't have that kind of law. And the court also kind of said, one or two laws or even 3 or 4 is not good enough. You need a lot more than that. And so certainly and seem to be looking for there's some language about you don't really need a dead ringer, but maybe some of them really were looking for a dead ringer. And that was really, I think, the core debate that the court was dealing with in Rahimi is that level of generality question. And you ended up with an 8-1 decision with everybody but Justice Thomas in the majority, which is interesting since Justice Thomas was the author of Bruin. And Justice Thomas took the very hardline view of like, look, there were domestic violence orders in the past, there were other similar things in the past, and while there were lots of ways that they were addressed, people were not actually disarmed, and that's the end of it for me. And the majority took a little bit, took things up a level higher and basically looked at 2 sets of laws historically. One was these surety laws where basically you had to post a bond if you had engaged in any kind of, if there was reason to believe that you were going to use a firearm to injure somebody, you had to post a bond to be able to continue to carry it. And then they also looked at, there were laws that criminalized kind of carrying a firearm to the terror or of other people and kind of carrying it for impermissible results. And they said, look, we look at those 2 sets of laws, and from that we divine a tradition of the legislature can, as to people who are identified as posing a risk, a specific risk to others, it can take measures to keep them from having firearms. And they said that's good enough for us. It doesn't need to be that it operated exactly as this law does. I think, in a sense, this is not closed, but even reopen and cause more debate about the level of generality thing, because now you've got a lot of people, we're litigating a case right now where the lower court basically said, well, as long as you're passing a law in service of like preventing crime, like, you know, they did that historically, so we win. And you know, I don't think that's quite what the court meant, but there's a lot of gray area in there to figure out exactly, you know, how many laws are enough, exactly how closely on point do they have to be, and you know, especially in the context of banning certain types of arms or banning certain types of people from carrying them. I found really interesting, you know, one of the things that gets a little lost in this debate about, oh, did they back away a lot from Bruen? There's 3 opinions from members of Bruen who wrote separately, all to essentially reaffirm their commitment to the project of historical tradition and engage in debate about how they think they should do it. And I think Justice Kavanaugh's is probably like the most elaborate and interesting, and he wrote the original opinion back in the day in a case that's known as Heller 2, a remand case from the original Heller, where he laid out in a dissent how he understood Heller as creating a historical tradition test, and that kind of became the foundation for the Bruen case. So you've got a really, you know, a great, interesting opinion that I commend to anyone who's interested in understanding how the court's thinking about all this, separate writing from him that's really talking about in defense of the historical tradition approach and trying to work through it. And Justice Barrett wrote separately to do that as well, and Justice Gorsuch. So, you know, in the mess of all of this, have they backed away? You actually had like several justices writing to say, no, that's not what we're trying to do here, but we recognize that there's a lot of tricky things to figure out in this context, and that it's not going to kind of work overnight to figure out exactly how we actionalize the concept of resolving cases kind of exclusively on the grounds of originalism. So very, very interesting case. I will not say I was shocked by the result at all. I was surprised that the Chief Justice wrote this one. I did not see that coming. I mean, he wrote so many things this term, and that one I was just like, oh, okay. Yeah, I can sort of get it, but usually I see that coming because I follow avidly what I think the Chief's going to do.
I wonder whether it was, this is a pure guess, this is an interesting comment, whether because, as you said, it was Justice Thomas's opinion that in some ways was being limited, and maybe somebody with a somewhat similar level of seniority, maybe that comes easier or something like that, but that's kind of interesting. Yeah. I want to comment on history and tradition and tie it into one other case last term before we talk to this term, but quick question, Erin, especially from the criminal law perspective, do you have a prediction what the next case is up next? I mean, the one that comes to mind for me is when Justice Barrett was on the 7th Circuit. She talked about some of the rules against felon in possession when you're applying even when it's a totally nonviolent offense.
Yes.
Do you think that's maybe the next case?
I think
or
from a
what
criminal
would you think it would
perspective,
be?
that seems like kind of the major criminal issue.
Yeah. Okay. So. Maybe coming soon to a theater near you. I don't know of any particular case.
No, and they sort of did a little bit to you know, they made some headway on that issue in a way that I think is positive for criminal defendants in Rahimi, because at the end they have this little bit of a discussion about like, it's not enough that you kind of don't think someone's like trustworthy and stuff, and like just a little bit of stuff that is part of some of the arguments the government has made. And they were very aware of, you know, I mean, Justice Barrett like talked about the Range case that was out there from the 3rd Circuit dealing with this issue in the course of, so I think they kicked some of that back down, and it could find its way back up.
Interesting. Well, let me say one other word. One other word in one other case quickly about history and tradition, and then we want to make sure we don't look just backwards, but also forwards to this term and tick off a few of the cases for this term. But just to show how widely this methodological concept is permeating the court's docket, I litigated a case last term called Erlinger versus United States, dealing with the Armed Career Criminal Act and whether a subprovision is subject to the Sixth Amendment right to jury trial. Completely different context, not nearly the headliner case that Rahimi was, but we spent almost the entire argument there talking about history and tradition as well. And so many of you might remember that the Apprendi doctrine is probably most easily known, branded by the court in 2000, holds that when a fact increases a possible sentence range, it has to be found by a jury beyond a reasonable doubt under the Sixth Amendment, with the exception, decided the year earlier in a case called Almendarez-Torres, of a prior conviction. And so in essence, the issue in Erlinger was, how broad is that exception? What does a prior conviction mean? Does it just mean the four corners of the element itself, or can it mean something more? And under the Armed Career Criminal Act, that was important because you have to be shown to have had 3 prior convictions that qualify in certain ways, but they all also have to have been committed on occasions different from one another. And the issue in Erlinger was whether that different occasions finding was subject to the Sixth Amendment. And interestingly, as it got up to the court, the government actually agreed with the defense position that it was, because 4 years earlier, I think 3 years earlier in a case called Wooden, when the court did the statutory interpretation question of what the occasions clause meant, the government said, you can't read this very factually to go beyond the elements of the crime, because otherwise you're going to run into a Sixth Amendment problem. And then the court said, well, we're still going to construe it that way. And the government, in a sense, kind of stuck to its word, I guess, and said, well, we told you it was going to be a Sixth Amendment problem, and now it is, and we agreed the right to jury trial applies. So the court appointed an amicus to argue against our position in the case. And just to show you what kind of lawyer I am, even though I had the government on my side in a criminal case, I still only got 6 votes. But we did win.
It's all you need, so more than you need.
We did win in an opinion by Justice Gorsuch holding that the Sixth Amendment applies in this setting. But again, what was interesting in this case was all the history and tradition conversation. In Almendarez-Torres, Justice Breyer had written the opinion for the court. And he actually did use the word the tradition of recidivism being a sentencing factor. He cited things like the US sentencing guidelines and things that went back just a few years. Very recent tradition,
Different
you might
concept
say.
of tradition.
And we said, wait a minute, I don't think the court means, when the court says history and tradition nowadays, they seem to mean a bit more. And so we kind of excavated the historical, and actually I shouldn't claim this much credit for it, because Justice Thomas himself in his Apprendi concurrence did a lot of this, and we kind of built on that and showed that, certainly at the time of the adoption of the Bill of Rights and the 14th Amendment, the vast majority of states, there were a few outliers, had everything about a prior conviction, including that finding itself, go to the jury. So even calling into very serious question Almendarez-Torres itself on this basis. And sure enough, the very first question I got an argument from Justice Thomas was, shouldn't we just overrule Almendarez-Torres and just solve this whole problem? And I said, you don't have to in this case. And the other justices, I think, were happy to hear that. And that's how they decided the case. But whether Almendarez-Torres itself will come under, actual attack under the history and tradition test or not, I think that this area of law will, I think, make the exception exceedingly narrow. And so for those of you that might do cases that deal with recidivism statutes, not just something like a separate occasions finding, but like, were they committed on dates different from one another? Were the defendant behave well in prison between one or the other? And all kinds of sort of related to the prior conviction findings that many state statutes and federal statutes have, I think under this opinion and under history and tradition are going to fall outside of the Almendarez-Torres exception and inside the Sixth Amendment right to jury trial.
So we do want to spend a little bit of time talking about next term before we try and take some questions from folks. And continuing my theme today of talking about criminal cases that aren't exactly criminal cases, I will start with a few words about the Glossop case that's going to be argued in October. This is a death penalty capital case, and it's a really unusual one. The basic dynamic is that the state of Oklahoma confessed error as to the individual who's on death row, and the state court refused to accept their confession of error and ordered them to execute the individual anyway. We are actually representing the state, and the state alongside Mr. Glossop sought cert, which the court ultimately granted. So it's like just, issues aside, like that's just a really, really unusual dynamic and what is going on in this case. And so there's a court-appointed amicus who, oddly enough, is one of our former colleagues, who is arguing in defense of the effort by the state court to force the executive branch to commit, to execute someone that it has said it is not convinced committed the crime he was convicted of. The case is, so Mr. Gloss has been on death row for a couple of decades now for first-degree murder, but it's a case where no one says he committed the murder the individual who did said he paid him to commit it, and he was the star witness at trial against him. And during the trial, the government, putting him on the stand, elicited testimony from him about basically, have you ever taken prescription medication? And he said, I took some lithium, but not for psychiatric use, and that was kind of the end of it. It came to light in recent years that the government knew that he had actually been prescribed lithium shortly after the events, the murder, for bipolar, after being diagnosed as bipolar, and they essentially nonetheless elicited this testimony, and that they now, basically, the state has said, we recognize there's a really serious both Brady and NAPU problem here in that we basically elicited false testimony. And that's the basis on which the state, after doing doing a whole investigation into all of this, confessed error. They'd like to retry, so it's not an actual innocence case, but confessed error in the original trial. And they went through the courts, and they got to the Oklahoma, it's like the mid-level criminal court, the Court of Criminal Appeals. And that court refused to accept their confession of error. And also along the way, this is all in the context of habeas proceedings, the state had affirmatively waived invocation of any procedural bars that might exist in his habeas claims. And the court refused to accept their explicit waiver of procedural bars as well, and said, no, we just get to decide whether they exist. So the state court said said procedural barred, and said, we're not convinced there was a violation, and if there was, it was harmless error, basically. We think the jury would have convicted anyway. The Supreme Court, and then Mr. God's, the governor can't commute the sentence without the approval of the parole board in Oklahoma, the Pardon and Parole Board. It just so happens the prosecutor's husband is a member of the parole board, so had to recuse, so it's 2-2, and they split, so you can't deal with this through that dynamic either. So everybody goes up and got an emergency stay from the Supreme Court to not have to move forward with the execution. The court then sat on the case for over 3 months, 3 or 4 months. So it seems like they were probably thinking about writing my sense is there was probably some effort to write a summary reversal. That seems most likely. And then they ended up granting cert and adding a question of whether there's an adequate and independent state ground that bars consideration of the constitutional questions and constitutional violations here. My read on all of this is I don't think the question of whether there was a constitutional violation here is not particularly hard. And so my sense is, the court really took this because somebody talked somebody out of doing the sum rub and saying we need to take a serious look at this AISG issue, and that's really kind of what's driving where we are. But I just, it's complicated, and there's a whole factual history. For my money, I just have a really hard time seeing the Supreme Court say, yes, you have to go through with the execution of somebody as to whom you have confessed you do not have confidence in the conviction that currently exists. So it'll be an interesting one. That's being argued in the October sitting.
Yeah, that would talk about due process.
I
Right?
mean,
So I would talk about another case for this term that the Due Process Institute actually did file a terrific brief I'm going to mention in a minute. This is called Coussis versus the United States. The court is going to revisit the mail and wire fraud statutes again from a substantive criminal law perspective. So I'm sure many of you practice in this area and are familiar with these laws. There's the due process brief written by John Klein. It's a fantastic piece of writing, and it starts by kind of telling the story of how the statute has been litigated over time. And I'll just read you a passage from it. In 1980, then still a prosecutor, now Judge Rakoff, wrote that from the federal prosecutorial perspective, the mail fraud statute was our Stradivarius, our Colt 45, our Louisville Slugger, our Cuisinart, and our one true love. And he went on to write, where legislatures have been slow to enact specific prohibitory legislation, the mail fraud statute has been frequently the sole instrument of justice that could be wielded against the ever-innovative practitioners of deceit. And I think that pretty well sums up kind of how the mail fraud statute in the 70s and 80s was wielded in this country and came to be kind of understood by federal prosecutors. Then in McNally, the court kind of tried to put a pin in that and said, no, the mail-in wire fraud statutes are property fraud statutes. They're not all-purpose deceit statutes. And so intangible rights like the right to honest services or other intangible interests that may be subject to defraud don't fall under this federal statute. Congress did respond, of course, and reinstituted the concept of honest services fraud, which then the court limited again later. But leaving honest services fraud aside, the court has been steadfast in saying these are property fraud statutes, not all-purpose fraud statutes. And just a couple terms ago, the court reiterated that. There was a case called Simonelli that came out of the Second Circuit that dealt with the so-called right to control theory of fraud. The idea being when a governmental agency dispenses its money for a contract or a project or the like, it has a right to control that money and to make a well-informed decision as to how that money is going to be spent. So if in the bidding process, for example, there are lies or deceit that take place, that theory was that would violate the mail fraud statute. When the court granted cert in that case, the government had a bit of a change of heart about the right to control theory, which of course isn't a traditional property concept, and kind of rewrote its brief and said, no, what we really mean in these right to control cases is if there's fraudulent inducement in terms of entering a contract that causes the government to give up money, that's what we really mean in these cases. That's what really violates the statute. In other words, the government is giving up money. That's property. And if they do it by way of being deceived, that is what really violates the statute in a case like this. The court ended up saying in Simonelli, 9-0 opinion, well, hey, you can't change your theory this late in the game, so we're going to reject the right to control theory and leave for another day this fraudulent inducement theory. Well, 2 years later, here we are in the case called Coussis, which is going to test the fraudulent inducement theory. And I'm not going to be representing Mr. Coussis later this fall when the case is argued. And just in a nutshell, basically the issue as it comes to the court is the government is going to say, as I said, hey, we're giving up property in a case like this. We're giving up money under a government contract. This is a case about government contracts in the city of Philadelphia. But the retort from the defense side in these cases is, yeah, you're giving up money, but unless you're harmed by way of giving up that money, there's still no fraud. As a matter of common law tradition, history and tradition, where these statutes come from, it's not just that you give up money that with a little white lie that causes fraud. You have to actually be worse off for giving up that money. So if you got everything you paid for, but somebody just they said, hey, I know your brother. Your brother is a great friend of mine. Why don't you give me the contract? It turns out you don't know the brother. But then you perform the services just as well as anybody else would. There's a million versions of this. The question is whether that constitutes mail-in wire fraud. So that's just one hypo of many if you're interested in reading our brief. As I said, this is kind of the way the game is played these days. But we'll see what the court ends up thinking of this new version of what I would say is a broad conception of the mail-in wire fraud statutes, and whether, as we put it, the court's going to sort of try to end this game of whack-a-mole, where the federal prosecutors kind of keep coming up with new theories, or whether, I think maybe from the Department of Justice perspective, like, hey, we finally got it right. We finally struck gold. We figured out the way this really all fits together, and so we'll see what happens later this fall.
Well, it wouldn't be a criminal preview if we didn't talk about the categorical approach for some purpose. So I'll say a few quick words about the Delegati case, which is a crime of violence case. So this case involves 924C1, which has a heightened mandatory minimum for committing a crime of violence with a firearm. And as I'm sure folks know, at this point, the part of the crime of violence statute that's like left and matters is the part that says that the crime has to have as an element, the attempted use, or threatened use of force against somebody. And as I'm sure everybody also knows, these days we analyze this through the categorical approach of looking at the elements of the crime someone was convicted of, not of the conduct in which the individual actually engaged. The question here is, whether a crime that requires proof of bodily injury or death but can be committed by failing to take action qualifies as having as an element the use or attempted use of force. So this is a state statute that would basically allow for conviction if you stood by while somebody was suffering injury, if you kind of did nothing in the face of it or didn't give someone aid that they needed, that could qualify as a basis to be convicted of the crime, even though you yourself are not the one who used or even kind of put in motion the force that's being used. Mr. Delegati here says, this is kind of straightforward. Like, you are not using force if you are not actually doing anything to anybody. If it's just that by your omission somebody suffers some sort of force, that doesn't qualify in the way that the statute contemplates, because the statute contemplates an affirmative act. The government hasn't filed its merits brief yet, but essentially their argument is kind of like, if you benefit from the use of force, you have used the force, even if you didn't use it yourself. You've kind of used it in the meaning that the statute contemplates. I think the statutory argument seems to me kind of hard to make that work. And there's also something a little bit counterintuitive. If you remember what this statute is actually about, which is a criminal enhancement for carrying a firearm, like, it's a little weird to think that you're super, you really want to reach out and get the people who carry a firearm while doing nothing to somebody else. It makes a lot more sense to think about that as a criminal enhancement in the context of someone who's using it in an affirmative way of using force against somebody. So, but all of that said, I'm quite sure we'll end up in this case with like another lamenting separate opinion that says this is all so far off the rails because clearly none of this should be benefiting Mr. Delegati, who's like not even close to somebody who actually could claim that it was all involving omission. So we may have some more debate this year about some of the members of the court who are not super big fans at this point of where the categorical approach is taken in court.
I can only imagine people become federal judges and they're like, oh my God, this is the job? Federal.
When you do just look at this stuff and you have to remind yourself, no, like that is the law. Like,
it's tough stuff.
He does benefit from this.
Yeah.
Like, I get it. I get where they're coming from.
Well, as Shana's standing up, I'm going to mention one last case very quickly, but I think it's important just so you're all aware of it. And in part because it involves the First Step Act of 2018, which DPI was a big mover behind getting that important legislation enacted. This, I think, will be the court's second look at the act. Different issue than the Pulsiver case last term. But remember, among the many important things this act does is it reduces mandatory minimum sentences for people convicted of drug and firearm offenses. And sections 401 and 403, which are the underlying provisions at issue here, prevent the practice of stacking, which used to happen with requiring these ultra-long sentences because you had to run these 924C counts consecutively, one after the other, and you get people with hundreds of years of extra punishment just simply for stacking 924C counts. And so basically what the Congress said is cut that out, and it's much shorter sentences nowadays. But the issue isn't exactly that, it's who gets the benefit of this new law. And the Act says that it applies not just to any crime committed after the enactment, but also to any offense that was committed before the date of the enactment if a sentence for the offense has not been imposed as of the such date of enactment. So pre-act offenders still get the benefit of the Act if a sentence has not been imposed. The question is, what does it mean for a sentence when a sentence has not been imposed? Certainly, if you've never gotten sentenced at all, you get the benefit of the Act. And everybody seems to agree that if you were sentenced before the Act, but your sentence was vacated at the time the Act was passed, you also get the benefit of the Act. But what if you were sentenced before the Act, and then sentence gets vacated after the Act? Are you somebody upon whom a sentence has not been imposed? And so this kind of brings us full circle about our nitty-gritty textualism. Justice Barrett, when she was on the Seventh Circuit, said, as a matter of plain English, if you were sentenced before, you're not somebody for whom a sentence has not been imposed. And in conservatives, a cadre of leading conservative judges have now debated this. Judge Kethledge in the Sixth Circuit agrees with then Judge Barrett. Judge Bibas on the Third Circuit has a leading opinion going the other direction, saying As a matter of legal terminology, once a sentence is vacated, it is as though it never existed. And so as a matter of, you might call it a legal fiction, but it's an important legal fiction. Once a sentence is vacated, you stand in the shoes of somebody who hasn't been sentenced at all. And so maybe one way to think about this case is when you do textualism and you do ordinary meaning, do you do ordinary legal meaning with legal fictions and the like in the background, or do you do just kind of regular English like somebody who hasn't gone to law school yet? And then also there's a very interesting purpose debate here, which is why on earth would Congress want to carve out the people at issue in these cases when they seem to want everybody who's getting a new sentence after the act to get the benefit of the new law, which they had decided was quite unjust. And so for the justices that are more purpose-driven or maybe even more consequentialist-driven, I think they may have a lot to say about that in this debate. And so we'll see. And yet again, it's a case where the government is siding with the defense, and we have an amicus being appointed to represent the lower court decision. So that dynamic
again
seems
is
to
a
be playing
former
out more and
colleague
more.
of mine. So
Pardon me?
who again is a former colleague of mine.
Yes.
So apparently that's your way to get an argument.
So yes.
Let's hope that goes better than Pulsiver last term, which was pretty bleak, in which I think it was Justice Gorsuch in his dissent pointed out that the court had just killed all the hope that Congress had given with the First Step Act. So hopefully that dissent does not have to be repeated this time, and it goes well.
Yeah.
We are now going to ask questions. While you guys all think about your brilliant questions, I'm going to do a little moderator's prerogative and ask you what the room full of criminal defense lawyers should start doing about Chevron. So in Loper Bright last year, Chevron deference was destroyed. Half of the people in this room danced on the graves of agency deference, and the other half wept because they were thinking about their favorite federal agency, maybe the EPA, and what power they just lost. But for those of us in the criminal space, Jeff, I know in particular, you've spent your entire life getting strategic about how to destroy terrible doctrines that do nothing to protect criminal defendants. What can we start doing with that Chevron decision? Where can we make hay in the criminal law space?
Well, I'm very interested to hear what Erin thinks. She may know more than I do, because I think she was more involved in Loper Bright and probably looked around more of the corners than I did. But even before Loper Bright, there was a very hardy debate about whether agency constructions, and particularly Department of Justice constructions of federal statutes, were entitled to any deference. And I think there was a good argument then, which never quite got fully resolved, that they weren't. And all the more so now. So obviously, any statute that is being used as a basis for criminal prosecution, where the agency has construed it to mean a certain way, whether it be an environmental crime case or something else, I think obviously, you don't have to think too hard to know that. I think the other area where this really matters, and maybe for some of the people in the room too who do a mixture of criminal and immigration work, is the INA was one of the most active agencies in terms of receiving deference day in and day out in the lower courts in this country. And so when you have the blend of criminal and immigration that come together, that's another area where the INA is not going to get the same deference it did before. And for one, I would say I think that's a good thing.
The Bureau of Prisons as well?
Sure. Yeah. Erin, I don't know. What do you think?
Yeah, no, nobody should be getting that kind of deference. I think one of the things that's important to remember, though, always when thinking about Loper Bright and Chevron more generally is, Chevron, it comes into play when you're interpreting a statute. Not every time an agency is asking for discretion involves interpreting a statute, and if you're in a context where an agency admittedly has discretion, at first blush, you might just say, well, none of this really matters. I think that's a mistake, and I do think it's important to keep thinking about how to use cases like Loper Bright and all the major questions doctrine, even in contexts where you might have some room for agency discretion, because especially if you kind of read, and actually the Kaiser opinion back a few years back that was dealing with like Skidmore deference rather than Chevron deference has some really great discussion on this concept of, even if an agency has discretion, you still have to interpret the statute and use interpretive principles to determine the scope of the discretion. It's not like it's all over once an agency says they have discretion. All of this front-end work still needs to be done in thinking about, maybe they have discretion, but there's statutory boundaries on that I think it's important to reinforce that so you're not stuck kind of arguing these issues in more of like an arbitrary capricious, just reasonableness construct. You're more baking into the front end. Let's have a real conversation about exactly what the boundaries are on what that discretion is. And I think if I'm the government, I'm trying to push more and more of it into the back end. So I think that's something to just be on the lookout for in contexts where you might still have some discretion for some of these agencies, because there are going to be things that Congress kind of gave them some leeway to do, but that doesn't mean they get free rein.
Are there questions from our audience? Because I've got another one locked and loaded. I can keep asking. Oh, I'm going to come over to Jason. Architect of the First Step Act right here.
Not architect of the First Step Act. Worked on it a lot, though. Way too much. I sent a text through our work text thread. So you guys mentioned the executive immunity case from last term. So my question is, or my concern is that the court is heading down a path of a QI, qualified immunity style process for executive immunity. That it's going to be a case or two before we really know the full extent, like where the court's going to land on this, what behavior actually, or what situational behavior actually qualifies as criminal, they can be held liable, or what's in official capacity. I know they gave some example of that, but I'm a lot more concerned about this, and with that, I'll note with fear for our democracy, and I state its concern. So.
You want to take the qualified immunity angle, maybe?
Yeah, I mean, in the specific context the court was dealing with this term, I don't know that they have to figure that out anytime soon, because hopefully it all just goes away in the specific context of presidential immunity, which is a little bit different from the rest. But I do think, more generally, Jeff's, I think we've actually been on the opposite side of a couple of these cases. There was a moment when it looked like the court may be backing away from immunity, there was some movement to back away from immunity, and particularly qualified immunity. It seems like that moment has passed, is my sense. There seems to be, not just from this case, but more generally, this court, I think there's enough of them who are not particularly troubled and who take a little bit more of a consequentialist view when it comes to immunity doctrines, and aren't really prepared to live with the consequences of even if history did kind of point them in a different direction.
Yeah, I mean, I don't know about you, Erin, but my takeaway from that moment where some justices were making noises about revisiting qualified immunity and then they decided not to, was that maybe one of the things that moved them was there were also some rumblings in Congress about doing that. And I think maybe the court is hoping that's where it's going to get resolved. And I think at the beginning of the program, we mentioned acquitted conduct, which is another one of these issues the court had been looking at for years and years, and finally they made some recent noises, and now we have actual rumblings of a change happening through the Sentencing Commission. And so I'd say if you want to try to curtail qualified immunity and that's something you care about, I think it's going to be a legislative fix, not a judicial fix that you're going to have to go after.
On it. We've been working on that. So Jeff, you actually mentioned earlier your case from last term, but you did not bring up something that I found the most fascinating, which was Justice Jackson's dissent in that case. As we all know, she is our beloved representative, finally someone from the criminal defense bar making it up to our nation's highest court. Her dissent in that case states that Apprendi was decided incorrectly, which shook me to my core, since it has helped many a criminal defendant. Mm-hmm. Her main takeaway is that it's getting in the way of legislative reforms that could actually bring more fairness to the system, which is something I spend my my day job at. Was she right? Is there a point? Was she wrong? What were your thoughts? Were you surprised by it?
Well, starting with the last one, I was a little surprised, although maybe I shouldn't have been. I mean, I think you mentioned one part of her biography, which is she spent a little bit of time as a federal public defender. She also has a couple other relevant aspects of her biography for this purpose. She was a law clerk to Justice Breyer. The term Apprendi was decided, and he wrote the dissent. So maybe that's relevant. And she also served on the Sentencing Commission, and I think very much believes in the project of regularizing sentencing through, guidelines or the like. And so, this is a long-running debate about whether defendants are better off or worse off under the Apprendi rule, and it played out in the Erlinger case as well, where the court-appointed amicus and Justice Kavanaugh's argument was saying, well, Isn't this going to hurt your clients to have prior conviction evidence put in front of juries? The answer is, and this is one Justice Scalia gave from the beginning, is just because I have a right doesn't mean I have to invoke it. If the defendant wants to waive the Sixth Amendment, or if the defendant wants to stipulate to the underlying fact, the defendant can do that. And even if the defendant wants to challenge the underlying fact, this is really more about Erlinger than the doctrine maybe overall, but bifurcation can be a solution to have the prior conviction evidence not taint the jury's guilt-innocence determination. And the court actually put that in the opinion as sort of the best solution. So, I don't claim to be more expert than lots of other people in this room, but what I do when I do these cases is try to talk to a lot of the kind of people in this room, and what I hear from people who actually try criminal cases is that the right is a valuable right that even if you're not going to use it in every case is important to have. So obviously she sees that differently though, and that was definitely one of the surprises of the term, to see her stake out that position, which she didn't even express at argument.
I find it interesting that like in several of these opinions where she's been, not on the criminal defendant side, she does go out of her way to explain that she's kind of there because she thinks she's doing criminal defendants a favor, which is just, I mean, it shows a lot about her thinking, just how methodologically. It also shows a lot about kind of her background, but it is a little bit of a trend.
I mean, that happened to me. I mean, we didn't talk about my Diaz case from last term about the federal rule involving mens rea evidence, but that was her theme, and that, I'm sure you're probably thinking of that too, which I argued 2 criminal cases last term and lost her vote in both cases. And she told, and because
you were mistakenly thinking you were helping your clients.
So I'm going to have to double down and do a little better next time. I mean, it was interesting,
All right, this is your last opportunity to ask the 2 most legendary constitutional lawyers a question.
Thank you. Yeah, George Redden with the Kip-On Strategies Group. My question is, you mentioned both with Justice Barrett and Justice Jackson, but others. I'm curious if there was a particular opinion, either one way or the other, in some of the less known cases where you were surprised, or maybe not surprised, but a particularly interesting point that you didn't expect to see from a justice, whether that's Jackson, Barrett, or others, that kind of goes against what your average person would expect from the conservative, liberal justice, or what have you. Thanks.
Anything coming to mind?
I mean, I just thought, one of the things I found really interesting, because I think so much about all this methodological stuff, was like this debate we saw Justice Barrett sort of have with herself over a series of cases about what like tradition means when it comes to thinking about historical tradition. And it sort of kicked off this idea of like she went on this kick of tradition shouldn't count for tradition's sake. It should only count to the extent it's telling us what like historical understanding was. And then it kicked off this debate with Justice Kavanaugh being like, no, like maybe tradition does count for tradition's sake. And kind of got into this whole like fascinating, like pulling out something that, pulling at a thread that I think has been hard for people who do this work to kind of be like, where do we put tradition in all of this? So when she put out the first opinion and didn't quite explain it, and everybody was like, oh my gosh, she just said like she doesn't like tradition. Is she backing away from all of this? And then this later one came and said, no, I have a nuanced view of like what it means. But I've, it's among her many separate writings that I've found.
She seems to really care about that stuff.
She really does, and she's really into also the like substantive versus non-substantive canons on statutory interpretation.
So I think we talked about was Justice Jackson's most surprising opinion of the term, perhaps. I'll just mention one other one, which wasn't exactly an opinion, but it was an oral argument that took place in the Idaho abortion case. I was on the losing side in Dobbs, and so I still follow these cases. And the issue in this case was whether a woman who presents in an emergency room in grave risk of bodily harm but not death has a right to an abortion under EMTALA, a federal statute that would trump Idaho law to the contrary. And so I think it was interesting in oral argument that it seemed like Justice Barrett, who is in the majority of Dobbs, and some people might have tried to paint with a broad brush as kind of rule against abortion rights in every case she sees, seemed supportive of the claim at oral argument there. And so you had what was shaping up at oral argument to be a 5-4 decision for the state of Idaho with the men on one side and the women on the other. Now, one reason why I can't cite any opinion to you is the case basically fizzled from that point, and the court just kind of kicked it back down for reasons that may be related to what I just said about what the vote was starting to look like, or maybe not. But just her substantive position at oral argument in that case, I think, was surprising to some people, and just another reason to think, I think what Erin was saying is we shouldn't assume her positions on things just based on kind of biography or whatever else.
No, and I was a little surprised by where she was and how aggressively she was where she was in Murphy.
Yeah.
That social media, the case about whether the administration kind of forced social media to engage in certain content moderation in violation of the First Amendment. She really dove in there into that record and really did an aggressive factual opinion to throw that case out. So.
Well, every year we come to this point where we're all sad that it has to come to an end. Can everyone help me thank the dynamic duo?